Good afternoon, Mr. Chairman, ranking member, members of the subcommittee. Thank you for allowing us the opportunity to testify here today. My name is Steve Crampton. I serve as senior counsel for the Thomas More Society, a national nonprofit law firm championing life, family, and freedom. I applaud this committee for addressing this vital issue. As the title of this subcommittee suggests, the Constitution and limited government, both of which are keenly implicated in this issue. FACE should be repealed, as Ms. Hawley just said, for one, because it's an unconstitutional law, and second, because it's an unnecessary federal overreach into a matter traditionally and best left to the states. I also urge this committee, however, to take action regarding the use and abuse of the Ku Klux Klan Conspiracy Against Rights statute, passed in 1870, which has, for the first time in our nation's history, been pressed into service for use against these peaceful FACE protesters. People like Mr. Vaughn and the others, many of whom, as has been mentioned, are already in jail today, face that penalty that goes up from 6 months for a first offense nonviolent FACE violation to 10 years in the federal penitentiary. This is an outrage, and it should not be permitted. Historically, FACE was always about one thing: abortion. The legislative history, the drafts of the early bill make this quite clear, as does the use and abuse of the FACE Act throughout its 30 years history. Moreover, FACE purports to prohibit intimidation of people on the basis of their views on abortion, whichever side they might take. But the weaponized Department of Justice and its Gestapo-like FBI are using FACE itself to intimidate and silence peaceful pro-life advocates. It is the government, not the peaceful advocates like Paul Vaughn, who are doing the intimidating here. Furthermore, since the historic Dobbs decision, June 2022, reversing Roe, there's no longer any pretense of abortion being a federal right. Because the reason for the law has ceased to exist, FACE itself should cease to exist. It should be repealed. But instead of the DOJ lessening its use of the FACE Act after Dobbs, what the Biden administration has done is increase dramatically, perhaps 100-fold, its application. Only after Dobbs was decided did they begin rounding up pro-lifers all around the country for incidents that had occurred years before Dobbs was even decided, and they've thrown the proverbial book at them. Many of these peaceful pro-lifers will spend Christmas next week away from their families, behind bars in the federal penitentiary, simply because they peacefully sought to interpose on behalf of helpless babies facing a most horrific and violent dismembering and death by abortion. And while those who sought to protect babies in any means now are at risk under this administration, regardless of their proximity to an abortion clinic, pro-abortion zealots who firebomb churches and pregnancy resource centers are left free to carry on their campaign of terror at will, even though churches and the PRCs are theoretically protected under FACE 2. Moreover, FACE was carefully crafted from its inception to criminalize only one side of the abortion debate, namely the pro-life side. This viewpoint bias in FACE is seen all too clearly when contrasting the cases of two of our clients, Mark Houck, who was already mentioned here, and Mark Crosby. This subcommittee heard from Mark Houck, how he was arrested at gunpoint in front of his wife and children, ended up facing several years in the federal penitentiary for 2 violations were charged of FACE. Thankfully, he won at trial, but only after going through the entire process. But contrast that case with that of Mark Crosby, 73-year-old pro-life advocate, brutally beaten on May 26, 2023, by a pro-abortion zealot outside a Planned Parenthood clinic in Baltimore, Maryland. Although Mr. Crosby offers counseling on so-called reproductive health services, should otherwise qualify for protection under FACE, guess what? His assailant is free from any FACE prosecution because they carefully defined what constitutes a reproductive health service and the counseling protected thereunder to be connected only to a facility. Because Mr. Crosby is on the sidewalk, he got no protection. What we have here is an out-of-control Department of Justice. The rule of law mentioned by Ms. Hawley has suffered, and it may prove to be a mortal wound. This two-tiered system of justice must end. Thank you. I look forward to your questions.